Mr. Devaney, do your clients, as you mentioned, you represent primarily employers, do they benefit from the National Labor Relations Board when they cannot function, it cannot do its business with a with two members only, and these three appointments were meant not only to fill the board, but also to increase its functional ability to deal with the things before it, even the most mundane and routine. So do your clients, do they gain, do they have a benefit by the fact that board cannot act?
Well, I don't think that it depends on the facts of the case. For example, I actually disagree with Ms. Davis with respect to the impact of delay. I mean, there were 100 cases that were appealed to the U.S. Court of Appeals out of the some 600 cases that were decided by the unlawfully constituted two-member board. Now, for every one of those 100 people, they had expenditures for lawyers, they had expenditures for their clients. Those were unions, those were employees, those were management. It wasn't, as I said earlier, I think it's an institutional process. It is true that unfair labor practice charges are, the number of charges filed against employers are much higher than the number of charges that would be filed by unions. So to that extent, I guess you could make an argument that, well, if the board can't function, it delays the decision making on those kind of matters. I raise another concern.
Well, because from the testimony, as far as I can see, employers, not to mention the workers and their families, I don't think they benefit from a dysfunctional board that cannot make decisions. That to me is even routine, mundane decisions can't be made during this period, and that to me seems to be really bad public policy in the sense that it's people are suspended without a decision, and no doubt in my mind there is a benefit derived from some employers of no decision being made and allowing this process to just be strangled with no decision.